Hello, my name is Josh Blackman, and welcome to the Harlan Institute Virtual Supreme Court competition. This is the round of 8, and we're mooting the case of Moody versus Net Choice. This is the, again, round of 8, and we have two teams today representing petitioners. We have Kevin Bisley and Max Steinberg. And representing respondents, we have Caroline Reedy from the Creek Tree School in Texas. Counsel, begin whenever you're ready.
Mr. Chief Justice, and may it please the court. The First Amendment's broad protection of the freedom of speech and expression defends just that, expression. Because social media companies' content moderation cannot be seen as expressing anything at all, Florida is free under the First Amendment to regulate it and compel factual disclosures about how a platform's terms of use are applied.
The First Amendment's guarantee of free speech and expression has made for a nation of free discourse. But the digital world, the new public square as this court recognized in Packingham, is a different story. At present, the social media corporations, represented by respondent, hold absolute control over what may be said on their platforms, and with this power, they can silence contrarian views and censor ideas they disavow of without any accountability. To bring the content moderation of social media companies into the light and curtail unfair moderation practices, Florida passed SB 7072 in 2021. The 11th Circuit found the law to infringe upon the free expression of social media corporations and impermissibly compel speech. We ask the court to reverse the decision below and uphold the law for the following reasons.
Firstly, the content moderation of social media companies is not speech itself, but only the hosting of a third party's speech. Under Miami Herald and PG&E, these both concern cases where editorial discretion was used to determine which speech could be posted in the first place. Under Pruneyard and Fair, which better fit the passive hosting of speech as on social media, content moderation is not expressive.
Secondly, the disclosure provisions of the law do not compel expression in violation of the First Amendment. Under this court's precedent in Zouderer, Florida may compel a corporation to divulge purely factual information about the terms under which their services will be available.
Thirdly, the common carriage doctrine of the English common law allows the imposition of non-discrimination requirements such as SB 7072. In the era of modern telecommunications, it is only sensible that this designation now encompass social media. As the law only requires fair moderation on platforms here, it is clearly permissible under this doctrine.
And finally, even if this court disagrees and finds a particular provision of SB 7072 to be unconstitutional, it should defer to the severability clause and allow other provisions to take effect.
Therefore, we ask that the court reverse the 11th Circuit, and we welcome this court's questions.
So, Counselor, this issue has sort of been alluded to in the briefing below, but what exactly does the Florida law apply to? What kind of internet companies does this law apply to?
So, Your Honor, the law would apply to any internet companies that are hosting user-generated content on their platforms. And so that would include your classic social media companies such as Twitter, Facebook, etc., and also things such as Gmail or perhaps something like Etsy.
Is it clear that a Gmail or a Hotmail or Yahoo web account would be covered by this law? Is that clear in the record?
Your Honor, I think there are some shortcomings in the record purely because of how respondents chose to litigate this case. They rushed for a preliminary injunction in the district court. We offered to stay our law to allow for discovery in the interim and cooperate. The district court refused. So we're in this position because of how respondents chose to litigate this case. We will say that what is clear is that the Florida law does have a substantial breadth. It has clear terms for the definition of censorship and for social media companies. And we think that that means there's at least some plainly legitimate sweep for the facial challenge here, Your Honor.
So I'll ask your friend on the other side of this in a couple of minutes. So I'll make sure I get both sides in this. But what is the relevant First Amendment standard for overbreath? Can you tell me that, please?
So, Your Honor, I believe this court's precedent show that the standard for overbreadth would be to analyze whether the numerator, sort of the fraction of cases that of applications of this law that would be invalid under the First Amendment is substantial compared to the denominator of the total number of circumstances in which this law would apply. With that in mind, however, respondents have not raised an overbreadth challenge below, and at least from their briefs, it did not seem like they're raising an overbreadth challenge here. And so I'm not sure the overbreadth standard would be the way to look at this case, Your Honor.
So do the respondents have to show that this law is unconstitutional in every single application to prevail?
We believe that it's respondents' burden to show that there is no plainly legitimate sweep of this law, Your Honor.
Okay. And what does that, again, I know you're reading from the cases, but what does this phrase mean? I'll ask Ms. Reedy this in a couple minutes. What does this mean, plainly legitimate sweep? What does that refer to?
Your Honor, let me clarify with a few examples. So if this law could be applied to the, let's say, non-paradigmatic companies we think the law applies to, like Venmo or Uber or Cash App, things like that, where there's no expressive concern really at all, then we think that clearly allows for a plainly legitimate sweep, and this law cannot be struck down on its face.
Okay, so could this law be applied to Uber? I'm not sure. Let me make sure I get your question right. Just say that again, please.
We think that this law could be applied constitutionally to Uber. We also think it could be applied constitutionally to Venmo as well. And the simple point I'm trying to make, Your Honor, is that
why could it be applied to Uber? Just can you just spell that out for me, please?
sure, Uber and Venmo and things like that, unlike the paradigmatic social media companies like Facebook or Instagram or YouTube, have no like news stream function at all. There's no expressive interest at all there. They're much they tack on much more clearly to any sort of common carrier analogy. We argue in our brief that even the paradigmatic social media company examples tack on quite well to the common carrier analogy, and that this law regulates conduct.
So
Not
Facebook, so Uber is kind of like a taxi, maybe that's the analogy you might use.
exactly, Your Honor.
And then I don't know, a Cash App would be like a bank. I don't know, I'm just trying to analogize. All right, I'll ask you from the other side this in a minute. I want to just get a couple other points clear. If let's say that we agree with the argument you're making here, that the statute would be valid as applied to Venmo and Uber and these other sort of non-social media companies, but let's say we disagree with you. Let's say that it's unconstitutional as applied to Facebook. What would our remedy look like? In other words, remedial. What would the remedy look like if that's where we want to go down?
So, Your Honor, I do want to first point out that respondents have not raised that particular as-applied challenge that you're referencing here. They've only raised the facial challenge. However, if an as-applied challenge with the paradigmatic social media companies were to come before this court could, as a remedy, enjoin the enforcement of SB 7072 with respect to those cases as applied, while still upholding it facially.
What about the stay that this court entered? I'm sorry, not this court entered. We entered one in the Texas case. What about the 11th Circuit ruling? Do we vacate that in part? I mean, what do we? I'm trying to think how do we actually, how would we write? And I agree, and Ms. Reedy can address this in a couple minutes that they've not brought an as-applied challenge. But how would this court potentially allow the law to go into effect for Venmo and Uber, which you might be right about, but maybe continue the injunction about Facebook and Twitter? How would we do that, Counselor?
So, Your Honor, this court should do that, vacate the stay of the 11th Circuit and remand the decision to the lower courts for fuller discovery and for.
Was there a stay? Hold on, I'll make sure the Texas thing. Texas, has there been a stay by this court of the 11th Circuit decision, or was there a stay of the Texas one?
It was a stay of the Fifth Circuit's decision.
Right, so, but we're talking about the Florida one here, right? How do we? What kind of remedy do we do for the Florida one?
Your Honor, I think in this case, all the court needs to do is lift the preliminary injunction and say respondents have not met their burden on an as-applied challenge, because that's just not how they've chose to litigate this case. And they've also not shown that there's no plainly legitimate sweep for this law.
Did they lose? Is this case over? In other words, can we even send this back down to the lower court to say file a as-applied challenge, or that we'd have to just file a new case and start from square one?
We think that they would have to start from square one, Your Honor, and that is not the fault of the state of Florida. It's because of how they chose to litigate this case themselves.
I'll ask your friend the same question in a few minutes. I want to make sure I get both sides on this very clearly. Let's talk a bit about the merits. We have a lot in the briefing about Miami Herald versus Turnilla. We have PG&E. We have Hurley. How do you address those lines of cases, please?
So, Your Honor, I want to just address the issue of editorial discretion here. Miami Herald and PG&E both made clear that the reason the newspaper and the gas company in its newsletter had the right to decide what could and couldn't go in those respective publications was because of editorial control and discretion. But social media companies, or at least the ones at issue in this case, have stated they do not have this sort of editorial control in past cases such as Tamina and Gonzalez. Just last year, these companies were singing a very different tune and arguing that they don't even know what's being posted on their platform, and they sure don't control everything that's being posted on their platform or have any sort of front-end review like Miami Herald and the PG&E company did. And so
does Miami Herald require front-end review? I mean, that was of course an aspect of that case, but Miami Herald talked about the monopoly, everything else. Didn't Miami Herald sort of speak to what we have here?
Your
So
Honor,
Miami,
sorry.
Go ahead. You might have.
Your Honor, sorry. I would just say that I think the real question in this case is whether these social media companies are acting as any sort of editor, and is an awfully unusual editor who doesn't even know that ISIS is on their platforms, as they represented to this court in Tamna just last year. So regardless of which exact case it tacks on, our point is that they're not an editor at all, because they expressly disclaim any relation to the content of their site. They say it's not their speech in their terms of service, as they represented to this court previously just this term, and as this court has clarified as well.
Okay, Counsel, your time is up. Thank you so much. Respondent, you have your 15 minutes. You begin whenever you're ready.
May it please the court. My name is Caroline Reedy, and I proudly represent the respondents' net choice in the case at bar, and will be arguing against both provisions of SB 7072 for the following reasons. 1, social media companies are not common carriers. 2, the willful deplatforming and individualized explanation requirement are unconstitutional. And 3, this law does not pass strict scrutiny. Your Honor, on behalf of Net Choice, I stand before you today and challenge a piece of legislation that not only threatens online innovation, but fundamentally misrepresents the nature of online platforms. Florida's SB 7072 seeks to impose burdensome regulations on social media companies, treating them as if they were common carriers, a classification that demonstrably fails to capture the unique role these platforms play in the digital landscape. Unlike common carriers, which passively transmit information without exercising editorial discretion, social media platforms are fundamentally different. They curate content, develop community standards, and foster specific user experiences. SB 7072 disregards this crucial distinction, attempting them to force platforms to host any and all content, regardless of its harmfulness or violation of their own community standard guidelines. This approach not only undermines the editorial discretion to platform operation, but also clashes with Section 230 of the Communications Decency Act. This landmark law recognizes that social media platforms are interactive computer services protected from liability of user-generated content. Section 230 grants platforms the freedom to moderate content in good faith. This allows them to remove, restrict, or otherwise manage content they deem inappropriate, harmful, or violating their terms of service, regardless of the viewpoint expressed, and it empowers them to engage in responsible content moderation without the constant threat of lawsuits. Furthermore, SB 7072's attempt to regulate social media like common carriers directly contradicts the Supremacy Clause of the United States. Section 230 establishes a clear national framework for online platform liability, preempting any state laws that seek.
Can I jump in? So, Counselor, I want to just talk about how this case has been litigated. Did Net Choice bring a facial challenge or an as-applied challenge?
They brought a facial challenge, Your Honor.
Okay, and so you tell me, what is the standard to show to prevail in a facial challenge?
Could you repeat that, sorry?
Yeah, what is the standard for you to prevail under a facial challenge? Could you just go through the standard, please?
Yeah, Your Honor, of course. It is the show that this law is, as it says, facially unconstitutional. That all parts that we are bringing forth and discussing in this today would show that the willful deplatforming provision and the individualized explanation requirement are unconstitutional in any time you put this case to the bar. Instead of an as applied challenge, where it would be a more case-by-case analysis. And we can see that this is facially unconstitutional because it infringes on the First Amendment rights of these social media.
I get that, but I mean, so your friend the other side explained it with a facial challenge. You have to show that there's no plain legitimate sweep, right? Do you think that Facebook that there's a First Amendment right of Uber to not take certain passengers?
Yeah, no, Uber, I'm not I don't necessarily know their specific guidelines and whatever, but there should be a.
Could Uber say we're not going to accept Facebook or ride requests from Democrats or Republicans? Would there be a First Amendment right to do that?
No, Your Honor, I don't think so.
What about Gmail, which is a popular email program? Could Google say, we're going to just start deleting all messages from Republicans or all messages from Democrats? Could Google do that?
No, Your Honor, because Gmail is a more private company. and so they could not do this to Gmail. But there is a distinction between social media platforms and Gmail or Uber because these are their private.
I got that. So I think I'm glad you said there's a distinction, right? There's a distinction. Wouldn't that mean that that the Florida law is valid in some regards, but maybe invalid in other regards? I mean, I think you and your other side agree that the law could be applied, that there's no First Amendment argument for Uber and YouTube, Uber and Venmo and these other apps. So maybe the law is constitutional in some ways, not others.
Well, it is because we are not necessarily applying these laws to Gmail or to Uber because there is a distinction between them and the social media platforms which it targets. These laws say that social media platforms cannot deplatform political candidates and they must have the individualized explanation requirement. And this is different from entities such as Gmail or such as Uber
I got that,
because
but doesn't that undermine your facial challenge? Because in other words, if the law is constitutional in some regards, not others, doesn't that mean that you don't win on a facial challenge?
No, because we were saying that it is the law isn't necessarily even relevant to Uber or Gmail or things like this because it is inherently different because sorry because it only applies to these social media companies and because we should not even look at this facial challenge onto these other types of companies because
Okay.
social media companies have the ability to moderate their content and have editorial discretion, which is inherently different than Gmail, which is a more passive form of communication between between two people or whatever it may be.
Okay, let me ask you the same question I asked your friends on the other side, if I may. The remedy. Let's say that we agree with you, we agree with Net Choice that you can't apply this law to Facebook and Twitter. But we think you can apply it to Gmail or we can apply it to Venmo or Uber. Don't we have to reject your facial challenge? I mean, how do we not, don't you have to start back at square one to use what the counselor said a minute ago?
Could you repeat the question? Sorry, I'm not sure I
If
understood.
we agree with you that the law can't be applied to Facebook, but the law can be applied to Venmo and Uber. Don't we have to dismiss your facial challenge? You have to go back to district court and sue for an as applied challenge?
Well, because this would be a different, if it were to say that it did apply to Gmail and to Uber, it would be different and would not necessarily need to go back as an applied challenge, but it it would be applied differently because the First Amendment primarily protects the public expression and the communication, though email typically happens in a private setting between individuals. So this kind of weakens the legal justification for even applying it to email. And if we were to do this, I guess it is possible we would have to remand back to the courts and say maybe it should be an as applied challenge. However, it is our contention that we can't even apply this law to these different kinds of entities because it is not what the law is intended for, and it is not these private platforms that have their editorial discretion.
All right, well, let's maybe pivot a bit to the merits. I asked your friends on the other side about Hurley, about PG&E, and about Miami Health versus Trinillo. Can you talk about those cases, please?
Yeah, sure. So I think that we should be applying Miami versus Tornillo because it shows that the government cannot compel the speech of things like newspapers or publish content against their will. And then we can see that using this rationale, that the government should not be forcing Net Choice to be hosting speech that they disagree with and compelling them to have this kind of speech on their platforms. And that is seen through the willful deplatforming provision of this law because it is forcing these social media companies to host the viewpoints of specific political candidates that they might not agree with, and that they don't want to be disseminated on their platform. Mm-hmm. And additionally, this willful deplatforming law is incredibly vague and it is burdensome. It is vague because we don't know what willful deplatforming necessarily means. Mm-hmm. And that ambiguity creates uncertainty for both the platforms and the users.
Well,
the platform.
But again, counselor, if I just want to sort of drill in this one point though. Is there in fact editorial judgment when I put in a post and I click tweet or click X, whatever I post now, right? Does social media exercise any judgment before that comes up? Because your friend on the other side said at the front end there's no judgment.
Well, yes, there's editorial discretion, maybe not necessarily before this comes up because obviously they don't know it's been posted yet. But once this has been posted, there is a certain editorial discretion of having this post even on their online platform. To say that they must host this certain type of speech, this certain type of post goes against their First Amendment rights because they have this editorial discretion, as we've seen in landmark cases such as Turner versus Turner Broadcasting, where they held that that the that publishers have this kind of editorial discretion, and the social media companies are similar to in this aspect, where they have editorial discretion on what posts are disseminated in their social media platform and what they are.
How are they actually exercising editorial discretion? I'm not quite, maybe I'm not quite seeing it, but they take stuff on the back end, right? If they say, oh, this violates our community standards, right? But 99.9999% of content that goes up stays up. Isn't that right?
Yes, Your Honor, but they still are engaging in editorial discretion just because it may not be super frequent. With their established
Is that really discretion though? I mean, it just seems that they're taking stuff down, to avoid maybe Section 230. In other words, they're removing stuff to comply with Section 230, but it doesn't mean they're really exercising editorial judgment though.
Your Honor, it is our contention that they do use editorial discretion because, like I said, while it might not be frequent, they do indeed look at each one of these posts, and it has to align with their community standards. And if it does not, they can take the post down or shadow ban or deplatform or whatever it may be, and they should maintain this right to their editorial discretion, as Turner has held.
Okay, so let's just say that let's say I don't agree with you, and I don't think that Turner is on point, and I don't agree with you that Turner is on point. How do you respond to this sort of the common carrier argument? Doesn't that sort of give the state some extra leeway because of the large market power of these firms to sort of regulate what they do?
Well, I argue that they are not under the common carrier classification, that they are not a common carrier, so they're not subject to this kind of government regulation. First, they're private entities, and they do not have a passive transmission of information. They receive this information and then they curate the content through algorithms and removals and community guidelines. And these actions reflect the platform's values, and more importantly, as I've mentioned, constitute a form of expression themselves. They have the authority to choose what content appears on their publications, and they deserve the freedoms to define their communities and uphold this through their moderation.
So let me ask you a different question. In other countries around the world, social media companies exist without the First Amendment. And I get that, our country is different, that we have a First Amendment, but a lot of your arguments saying that Facebook cannot exist under this sort of regime, isn't the experience in other countries shows that they sort of do exist, and they don't all go out of business because they have to provide explanations for their takedowns and shadow banning? I mean, the fact that Facebook can exist outside the United States shows they can exist without having this rigorous First Amendment protections.
Well, while they can still exist in other countries, does not make this law any less unconstitutional. While other countries might still have a functioning Facebook or whatever it may be, since this law is applied in the US under our common law, and seeing that it violates the First Amendment, it doesn't necessarily matter that some other states can still have these kind of social media companies up and running in their states, because it is still unconstitutional under the United States law, because it forces speech of these social media companies that they may not want to host, and it forces the individualized explanation requirement, which is inherently burdensome.
Okay.
The individualized.
You may wrap up.
Sorry?
You may wrap up.
You'd like me to wrap up?
Yeah, you can wrap up. Yes, go ahead. I'm sorry.
Oh, okay. Yes, Your Honor. Well, SB 7072 is unconstitutional because it has been preempted by Section 230 of the Communications Decency Act. Social media companies are common carriers, and the willful deplatforming and individualized explanation requirements are unconstitutional. Additionally, it does not pass strict scrutiny because it does not have a legitimate and compelling government interest, and it is not narrowly tailored to meet strict scrutiny. And it is for these reasons that I ask you rule in favor of the respondents. Thank you.
Okay, Counselor, you have your rebuttal time, 5 minutes.
We'd like to go through respondents' principal arguments about the law in turn. First, that it conflicts with Section 230. Second, that it is no plainly legitimate sweep and fails a facial challenge. Thirdly, that it hinders a protected right to editorial discretion. And lastly, that the social media platforms are not common carriers. First, on the Section 230 point, Section 6 of the law says that nothing should be construed to be in tension with Section 230. And Section 230 already gives these companies protection for good faith content moderation. Really, these companies are here asking.
Counselor, wouldn't complying with this law potentially put them in violation of Section 230? In other words, Section 230 says you have to take stuff down in certain contexts, and your law makes it a lot harder to take that stuff down. Isn't there, I agree on their face, there's no preemption, but isn't it possible that Section 230 may lead to conflicts in how this law is actually enforced?
I think the distinction, Your Honor, is between good faith content moderation and bad faith content moderation. Good faith content moderation, we understand Section 230 deals with for the respondents. What they're really arguing for the court is for a right to engage in bad faith content moderation.
I mean, how do we, Counselor, come on, you're lawyers, right? How the heck do we know what good faith and bad faith means? I mean, we can write an entire treatise of, law and what good faith means, but this is very subjective, and we're dealing with the First Amendment here. How do we know what the hell, what the heck, it's a long day, what the heck good faith actually means?
Well, I think that kind of gets into the vagueness point that respondents allude to. So vagueness, the argument they're making, is just not part of the preliminary injunction that you have before the court, Your Honor. So that entire point is immaterial here.
So, Your Honor, I'd like to.
But but just let's say, use an example. Let's say that there's speech that maybe perhaps not defamatory, but there's some social media post that could trigger liability under Section 230, but does not run afoul of Facebook's own policies. So in other words, Facebook can't give a good reason why they want to take it down according to their policies, but they realize if they leave it up, they might have Section 230 liability. Isn't there a problem there?
Your Honor, I think that would firmly fall within the good faith exemption in the Florida law and the Section 6 provision that says that nothing should be construed to be in tension with Section 230. In the specific nuances of the law, I think it's important to note that there's been no definitive state law interpretation of SB 7072, and that's just because of the posture that respondents have chosen to litigate this case.
Okay. All right. Counsel, we proceed.
Yes, Your Honor, I'd like to just touch briefly on the issue of the facial challenge. So under this court's precedence, the burden of respondents here is to show that Florida's law has no plainly legitimate sweep, and this they need to meet in order to succeed on the facial challenge. But irrespective of whether this law can survive any as-applied challenges with the paradigmatic social media companies like Twitter and YouTube, respondents in their argument acknowledge that it could constitutionally apply to companies such as Uber and Gmail. And so this would constitute the plainly legitimate sweep that is required for SB 7072 to survive.
Are we sure this could apply? I mean, was this developed in the district court about Uber and Cash and Venmo, and was this in the district court litigation at all?
So, Your Honor, the district court litigation was accelerated by respondents' request, and so this did not necessarily get fully fleshed out there. And so,
if we remand it to the trial court, do we leave in other words, can we remand it to the trial court while leaving the preliminary injunction in place? Is that something that we can do here?
Yes, Your Honor, this court could, if it thought it appropriate, remand the case to the trial court with instruction to consider sort of whether that would be would constitute the plainly legitimate sweep, and to look more at the Gmail, the Venmo, the Uber cases, and then that could be returned to this court at a later time if necessary, with the preliminary injunction in place until then, if this court did think it necessary. However, I'm not sure that it would be necessary for the court to leave it in place.
All right, let's go to the third point. You said them in common carriers. I'll make sure your third point in your rebuttal.
Sure. So on common carriage, social media companies are precisely the forums of the modern day public square that this court described in Packingham. And common carriers are an apt analogy for the role social media platforms play today because respondents correctly understand that a common carrier is a mere conduit for speech, and social media companies fit precisely that. And so there are several examples that really tack on well here. The telegraph company, the internet service provider, or the delivery service all clearly carry speech, yet do not have license to snuff out speech they carry, nor to cancel any sort of disfavored speech.
And so, Your Honor, as this court has recognized before, the First Amendment preserves an uninhibited marketplace of ideas in which the truth will prevail. And Florida should not be prohibited from fulfilling this promise in the modern day digital public square.
Thank you, Counselor. All right, the case is submitted. Very good. All right. You guys can take a deep breath and relax. That was excellent. As you can tell from last round to this round, we had the actual oral argument, which is a weird part of this competition, which I'm sure you all were aware of. And when I was listening to the argument before the U.S. Supreme Court a few weeks ago, I was like, wow, they're focusing on none of the things that we were focusing on in our first round. Isn't that something, right? All the things that we were talking about came out like, 4 or 5 minutes, but they were almost all talking about Google and Etsy and Venmo and PayPal and the like. So I kind of decided like, okay, well, I can take a lead. So I sort of rejiggered all of my questions to sort of address what came up. And I think both teams sort of recognized this facial as applied distinction is very tricky. Just one case we think about, I think is in your briefs, which is Nifla versus Becerra, which is a 2021 case. I'm actually teaching it tonight in class, so it's a good timing for my students. And this was a case about not Nifla versus Becerra. I'm sorry, the right wing. AFP versus Bonta, BONTA. Sorry, I'm teaching. I taught Nifla last week and Bonta this week. So this is Americans for Prosperity versus Bonta, BONTA. And this was about whether California could require nonprofits to submit a document listing all their donors above a certain threshold. And the group said, we can't give you our donor list because our donors might be harassed, right? Our donors might be subject to retaliation by people who don't like them giving to our causes. And the dissenters in that case was Sotomayor saying, well, maybe you're right. Maybe there's evidence of some sort of discrimination or harassment against the two named plaintiffs. But that doesn't mean to strike down the entire statute. In other words, there might be some valid ways a statute can be applied. And the majority said, oh, that's nonsense. If there's harassment across the board. And then you have Justice Thomas concurring in the judgment. And Justice Thomas does not believe in the overbreath doctrine. Maybe you don't know this. But Thomas has actually been very skeptical of overbreath. And he says we should only issue remedies for those who are injured. And this is grounded in sort of the Article 3 standing issue, right? You can't enjoin a statute for non-parties. So I think this is going to be a very big part of the case. So if either or both of you advance next round, read Bonta carefully, read Justice Thomas's concurrence carefully, and review how the majority and the Sotomayor dissent sort of responded to it. I didn't want to push you too hard on this because we didn't really develop this last time. I wanted you to think about it. In terms of the advocacy, very well done. It's always easier to sort of argue by yourself because you don't have the handoff. With Max and Kevin, a couple of times you sort of just was a little awkward, the handoff, where you weren't sure who was going to speak. And I don't know if there's any good way of handling this. You're a couple thousand miles away, so there's no like good way of doing it. Caroline, she had her teammate was next to her last time. Now she's solo, she didn't have that issue. But just something to think about is either have a strict alternate rule or understand that there's a follow-up. Who gets a follow-up question? That might be the one to just sort of think about how to navigate that. I think both teams didn't have good answers to the district court litigation because it wasn't developed below. I think both teams sort of just said, well, those preliminary injunction, it was fast moving. That was the best answer you can give. I think both sides had good arguments on Hurley and PG&E and the Tornillo case. And by the way, it's Tornillo, not Tornillo. His name was Pasquale Tornillo. He was Italian. He was not Hispanic. So they kept saying Tornillo because they're all, Tornillo. Right? No, it was Tornillo. He was an Italian. Just for you to know. In terms of your performances, you're both confident. You're both well paced. Your diction was good. There's no stuttering, no stumbling. Even a couple of times I asked you a question that I don't think you knew the answer to, and it didn't even flinch, right? I didn't even get a hesitation. So you actually were very confident upon this. I was much more aggressive. I interrupted you deliberately, very aggressively. I didn't let you speak. It's not because I'm a jerk, maybe because I am. I had a flat tire this morning, right? But I was trying to sort of simulate it. And if you listen to the actual argument at the Supreme Court a few weeks ago, they didn't let the guy speak, right? They didn't get more than a few words out. And it's very, very aggressive. Those are my comments. Daniel, anything you want to bring up?
Yeah, from an advocacy standpoint, good job on both teams for the petitioner. Great job. I think this round you did a better job judging time for each person. I know it was kind of hard jumping in and deciding who was going to answer the questions, but I think it was pretty even as far as the merit of the argument. And for Caroline, good job doing the entire argument by yourself. That's hard. I don't know how long ago you started preparing for this, but if I didn't know any better, I would have known that you'd had the entire 15 minutes to yourself. So great job. That's
and kudos. I know you had short notice that your partner was not going to be participating, but that's it's commendable that on short notice. I want to just echo what Daniel said. This is the real world, right? You might be a lawyer one day and your lead counsel gets sick or he gets a flat tire. Look, it happened. Yeah, it happens, right? And you know what? If you're the second chair and your lawyer's stuck in a car accident, guess what? Judge was like, counsel, you can proceed, right? That's it. It's your show. There's not like a, can we come back later? It's not like when the judge says, you know what a default judgment is, right? Default judgment is the court calls your case. If you're not there, you lose. And that's it. There's not like a whoopsie, like any of you guys are late to class, like, oh, I'm only 2 minutes late. You're a minute late, the court calls your case, judgment entered, default, you lose. So Caroline, I'll give you credit that on short notice, you stood up, and you handled the entire case yourself, which is very good. All right, Daniel, I interrupted you. I'm so sorry.
No,
he was making a really good point. I want to echo what he said.
No, I think that's about it. I love watching the later rounds because clearly both teams deserve to be here. And good job.
Okay,
that's it.
Any questions you want to ask for me or Daniel?
I think I'm good. Thank you so much.
Yeah, the only question I had is what does the schedule look like in terms of when we'll hear back on the scores?
We have 2 more rounds today. I have another round tomorrow, so probably by Thursday or so of this week, maybe Friday at the latest, we'll get our scores posted. And then we will let you know about the round of 4. So 2 teams will advance, 2 petitioner teams, 2 respondent teams. And I've already sent you guys notice about the timing in DC. I think I have your schedules. It's going to be tricky depending which team advance because some of you coming from different coasts. So the traveling is actually, I won't bore you with the details. It's very complicated to work out the logistics of the court and everything else. But we're going to make it work. And all right, any further questions? Case is adjourned. Thank you so much. And I will see you all in the very near future. Thank you.
All right.
Thank you.
Thank you.
Thank you very much.